Hi, I'm Darcel Lobo and I own Dow Law Firm, and today's question we're going to be talking about: should you quit claim your home to your children, whether it's one child or multiple children? They have to be over 18, so we're talking about adult children here, but that's a question that I get a lot of times from clients who maybe are thinking of putting their home in their children's name for whatever the reason may be. And when we talk about that, we have to talk about kind of the why behind it and the intention behind it. And I also have to help my clients kind of evaluate if that really is the right option to achieve that objective. So there's some things that they may not have considered that we're going to talk about today. So the first thing is to understand that if you quit claim your home to your child or to anyone else, you lose all control over that property. You don't have any ownership, you have no say, you have no authority to do anything in regards to that property. So just ensure that you understand that you are fully giving whatever rights that you had in the property, you're giving that to somebody else when you deed that property to a child or to anyone. Also, there's tax implications potentially, right? So there's different types of taxes. We've talked about excise tax here in King County. I'm in the Seattle area for that transfer tax and how a gift can be an exemption to that. But there's other types of taxes to consider as well, and taxes that may come up down the road, and that's going to be capital gains taxes. So you have a basis in the property. We're going to talk a little bit taxes here, but not too detailed. But there's a basis that you have in the property that probably relates to when you bought it and what you bought the property for. Okay, and the capital gains tax is that appreciation, the value of the appreciation over the years of your ownership. Now, there are exemptions as to how much you can have in that equity before there's a capital gains tax. But that's not the point of this. The point of this is to explain that if you gift your real estate to someone else, to a child, their basis for capital gains tax purposes is not going to be the value of the property when you gifted it to them. It's going to be the value of the property based on your basis. So if your basis is from 10 years ago, 20 years ago, 30 years ago, maybe it's a family home that you've owned for a long time, whatever your basis is in that property, that's what you're giving to your child when you transfer or deed that home over to them. So whatever your basis is, that becomes their basis. And if they sell the property, their capital gains will be calculated from the basis that they got from you. Versus if they inherit the property from you, whether through a will, through a trust, a transfer on death deed, there's various options to consider. But if they inherit the property upon your passing, they get what's called a step up in basis. So they don't have to use your basis. They get to use the basis from at the time that you've passed away, which can be a significant difference if you've owned the property for a long period of time. Now, I'm not a tax attorney. I'm not a tax professional. When there's tax questions that my clients have, I'm referring them to their CPA, to their tax professional, and we're all working together collectively to put my client's plan together. But I can just tell you from what I do know in my estate planning is that there are some capital gains tax considerations to think about when gifting real estate to someone. Next up are liabilities. If the child that you're gifting that property to has any kind of past due debts, judgments, tax liens, owes child support, any kind of judgments against them, or owes a government entity or any kind of taxes, that can immediately attach to the real estate that you've given them. So if they have a judgment against them from a few years ago and you deed that home to them, that judgment from prior can attach to that home immediately. So something else to consider if you are possibly aware of your child or whoever the person you're gifting the property to, that they have any kind of financial concerns, just know that that real estate that you give to them, that you deed or gift to them, can be attached to by that debt. We went over step up in basis again. There just are some tax considerations to look at And so make sure that you are talking to a tax professional who can kind of help you figure out the basis question and ensuring that you're making an informed decision when you're gifting that property to your child, that they are going to receive it with the same basis that you have. And then also, sometimes clients are not aware of the other options available to them. We talked about a will, we talked about a revocable living trust briefly in a prior description earlier. I have plenty of other videos about estate planning tools like wills and trusts, but also there's transfer on death deeds. Now this is specific to Washington, and I am only licensed to practice in Washington. If you are outside of Washington state, I would love to help you, but I cannot do so. But with a transfer on death deed, you're essentially naming someone as a beneficiary to your home, and upon your passing, that home goes to them. So we have some other options besides just gifting real estate to someone during your lifetime. And it's not that you can't do so. It's not that gifting real estate is a bad idea, not at all by any means. But you just want to ensure that what your actual intentions are and what you want to do and your objectives are actually being realized through a quitclaim deed, through gifting and real estate. And that maybe another option may or may not serve you better for your objective. So talking to an attorney about what the options are, what your objectives are, and coming up with a plan that reflects that is really the best advice I can give you if you are considering transferring real estate to a child or to anyone else. If you need help with your estate planning, if you need help with a deed transfer, give our office a call. Our number is 206-408-8158. You can visit us online at dowlawfirm.com. I'll have all that below for you, and we'd be happy to help if we're able to do so. All right, thank you and have a good day.